began work at the White House. And Bud was on that list. Also, as indicated by other public documents, I knew that Bud would be asked to leave before he did. Regardless, I was not at liberty and in a position to disclose that to him. Elizabeth and I routinely discussed whether I would go back to the White House after my Army tour, and if the U.S. Attorney position would open up during my absence. I suspected, based on my conversations with Bud, that he might leave on his own. My initial worry was that Bud would either leave of his own volition or would be asked to leave while I was on active duty, and someone else would be chosen to be U.S. Attorney. In retrospect, that was apparently a worry without foundation, but I did not know that for certain when I left the White House in 2005. In fact, Bud expressed this exact concern to me in an April email after I told him I was headed to Iraq. He asked, how long in Iraq? Where? How are you going to be the next U.S. Attorney here when I get a job this summer and leave? So when I learned from Bud that he had been asked to leave in the summer of 2006, I wasn't surprised. Certainly, if Bud was leaving, I hoped to be his successor. As I said, we had talked about that, no doubt about it. But no one promised me the U.S. Attorney position, nor could they, because the President personally decides that. I knew that I had friends in the administration who valued my service and who thought my skills and experience fit the position, no doubt about it. I knew I had friends who wanted me to have that job, no doubt about it. For that I was and remain grateful. In fact, I would have been shocked. I would have been hurt if an individual who had a strong legal education and background, worked on both of the President's election efforts, had served the Department of Justice, had served on the President's staff, had served in Iraq, would be denied consideration for a U.S. Attorney position in his home state, just based on what I know about previous appointments, both in this administration and other administrations. But anything could happen in Washington, and as you can probably gather by now, it was all about making sure I had an option so that I would not be jobless. I did not have the liberty of being unemployed. So anything could happen in Washington, so I kept an eye on openings at the White House throughout my military service in case I had to return there. As I mentioned, there was a slot for me, but I wanted to make sure that there was something to go to. I didn't want something to sort of create and get out of check. From the beginning of the U.S. Attorney process, I intended to go through with Senate confirmation and actually began completing the paperwork for that process. In fact, I think that paperwork was emailed to me in Iraq. At some point in the late summer, I learned of the Patriot Act provision that allowed for an indefinite Attorney General appointment. Ultimately, I wanted to be confirmed by the Senate, and naively perhaps thought I would be. But I was amenable to accepting an appointment that met the requirements of the law. As United States District Judge here in Little Rock, Tom Isley said in his opinion upholding the legality and constitutionality of my appointment, although the present arrangement might, quote, although the present arrangement might result in de facto U.S. attorneys serving for lengthy periods without the Senate's confirmation, that possible result is the product of Congress's own making and could be changed by new legislation, end quote. He continued, whether good policy or not, I guess that's the question, whether good policy or not, Section 546 of the Patriot Act clearly expresses the will of Congress that the Attorney General have the authority to make interim appointments, end quote. After taking office in December 2006, when insurmountable objections were made to my candidacy by my home state senators who do not share my political affiliation, I had to consider the challenge of a recess appointment that was a legal possibility, but that was not my call. In fact, the manner of my appointment was ultimately never my call. I had to take into account the infinitesimal probability that Senate hearings would focus fairly and objectively on the actual merits of my qualifications, experience, and service to my country, despite the highly polarized political environment we have today in Washington. In the end, I did not think it would serve my young family, nor the state I love so much and have tried to serve honorably to subject us to such a process. Elizabeth and I are expecting a daughter, Mary Catherine, in August. We had a family to start. It was time to begin again. So in February, before the White House sent my name to the Senate for confirmation, I withdrew my name from consideration.